That is a case-by-case scenario, but I think when the assumption that you should have as a client is that your case is going to go to trial. That's how I always prepare my clients, is that expect your case to go to trial, because we are essentially naming a doctor or a clinic or a facility out there in the judicial system and saying, you did wrong by me. And they're going to defend themselves, and they're going to defend their doctor or their nurse or their employee pretty hard, because they're out in the community as well, and they want to have the reputation that they're a good provider. So I think I always tell clients that they have to assume that we're going to go to trial. In Minnesota, there are laws regarding kind of how a case goes forward. And in medical malpractice, you are not required to have any sort of an alternative dispute resolution process, which means that a case goes to mediation and you try to settle it before you get to trial. That's not required in medical malpractice. Now, that's required in my other practice that I do, which is personal injury. That's a part of our process. But in medical malpractice, that's not. So I always tell the client to assume we're headed for trial. And if we get a possible mediation, that's a great added step, but don't assume that.